Dear learners, now I'm going to debate discuss another point from the topic of the Dower, which was left in my previous lecture while dealing with the Dower. I have already pointed out in my previous lecture that Dower under Muslim law is an exclusive right of the wife to which she is entitled to receive on the conclusion of the union of marriage. Meaning thereby that as soon as a union of the marriage is constituted or is brought about by means of proposal by one party and the acceptance of the same by other with their mutual free consent, union of the marriage is constituted according to the Muslim law. And as soon as the union of the marriage is constituted according to the rules of Muslim law, according to the rituals prescribed by the Muslim law, it confers on the parties a specific status. Legal status is conferred on the parties to the marriage. On the female, it confers the status of the wife, and on the male partner to the party of the marriage party, it confers the status of the husband, meaning thereby that as soon as the two persons of the opposite gender with their mutual free consent unite with each other to live with each other for the lifelong in accordance with the procedure prescribed by the Muslim law or the Sharia law, then the union of such two persons is called under Muslim law union of marriage. It is called the nikah or marriage. Ladies and gentlemen, as soon as the nikah is formed or marriage is celebrated, and finally it comes into existence, comes into being, immediately it gives rise to various reciprocal rights and obligations. Reciprocal rights and obligations arising or flowing from the union of the marriage under Muslim law are known as spousal rights and obligation of the parties to the marriage. They are known as spousal rights. And corresponding obligations are known as spousal obligations. The rights and obligations arising from the contract of the marriage or union of the marriage are of the civil nature because the marriage itself under Muslim law is said to be in the nature of a civil contract in view of the decision of the Justice Mahmood in Abdul Qadir versus Salima, Anis Begum versus Muhammad Istafa, and some other cases, a Muslim marriage has been held as a valid civil contract. And therefore, it gives rise to the various type of various kind of the rights and obligations which are by nature, which are in civil nature. Since they are in civil nature, they are therefore they are enforceable in the court of law as civil rights are enforceable in the court of the in the event of breach of either of them by anyone. Ladies and gentlemen, from the union of the marriage, one of the important right that flow or arise Our union of the marriage gives rise to a very specific and important right to the wife of a marriage, and that right is known as right to dower. Dower is an exclusive right of the wife under Muslim law. At the same time, dower is an obligation imposed by law on the husband of a wife. Therefore, it is the right of the wife as well as it is the obligation imposed by law on the husband. Wife is entitled to receive the amount of the dower, whatever amount of the dower is agreed upon between the parties, either before the marriage it was fixed, or on the marriage it was determined, or subsequent to the marriage the amount of the dower is specified. So, whatever amount of the dower is fixed by the parties with their mutual consent, that becomes the exclusive right in the civil nature of the wife of a marriage. And since the dower is to be paid by the husband, therefore it is the obligation imposed by law, Muslim law, on the husband, and until this obligation is discharged, wife is entitled to enforce it in the event the husband refuses to pay it or neglects to pay it or ignores to pay it the amount of the dower which is fixed by the wife. Ladies and gentlemen, I have already stated in my previous discussion that a dower under Muslim law may be specified or unspecified. Specified dower means when the amount of the dower is fixed in quantum by the parties either before the marriage or subsequent to the marriage or at the time of solemnization of the marriage. The dower, such amount of the dower is known as specified. Specified means that parties have fixed some amount of the dower to be paid by the husband to his wife either before the marriage or on the marriage or subsequent to the specified dower is further classified into prompt and deferred. Prompt dower is the dower which is payable immediately on the demand of a Muslim wife. And therefore, if the prompt dower is not paid by the husband on the demand of the wife becomes entitled to enforce it by refusing to cohabit with her husband. And if she deserts the matrimonial home companionship of the husband, and the husband files a suit for the restitution of the conjugal right, the court may pass a decree for the restitution of conjugal rights subject to the condition of the payment of the amount of prompt dower to the wife immediately before the enforcement of the decree for the restitution of conjugal right. So this is in-house remedy available into the hand of a Muslim wife for the enforcement of her unpaid amount of prompt dower. Because after the marriage, parties are supposed to cohabit with each other and thereby constitute a conjugal society so that they can fulfill their mutual obligation to the satisfaction of each other. But if the amount of the prom dower is not paid after the marriage or on the demand of the wife by the husband, her husband, on the repeated demand, or the husband refuses to pay it or does not pay it, wife will be entitled to enforce this right by depriving the husband of a right to cohabitation or right to live with her. And this is one way of realizing or enforcing the amount of prompt dower according to the Muslim law. Ladies and gentlemen, so far as the deferred dower is concerned, payment of the deferred dower is subject to certain contingencies. It is contingent upon the happening of a future event. That is, that is the this deferred dower becomes payable either on the death of the husband or on the dissolution of the marriage, divorce by the husband. Uh, in case there is a dissolution of the marriage or marriage has been dissolved by the husband, the divorcee will become entitled to claim the deferred dower, or deferred dower will become payable immediately on the dissolution of the marriage. Well, she can realize it by even by filing a suit uh, in the court of competent jurisdiction, and court may pass a decree against the husband requiring him to pay the deferred amount of the dowry. In case of uh, in case there is a dissolution of marriage by death of the husband, and amount, the certain part of the dower was deferred, pending, and there is a death of the husband. Then, on the death of the husband, the widow will be entitled to realize the amount of the dower from the property of her deceased husband, because the dower is a unsecured debt running over the property of the deceased. Therefore, on the death of the husband, her property will be taken or succeeded by his legal heirs along with the debt running over the property of the deceased. So, claim of the wife or widow for unpaid portion of the Mehr is an unsecured debt due to her from her husband or his estate, respective. It ranks like unsecured debts and is an actionable claim. During the life, the wife can recover the unpaid debt herself from the estate of the deceased, and if the predeceases the husband, the heirs of the wife, including the husband, becomes entitled to her dower. Say, for example, a lady whose Mehr was rupees 50,000 received from her husband during his lifetime some money in aggregate exceeding the Mehr settled on her. The largest of such payment was rupees 3,000. There was no evidence that these payments were intended by the husband to satisfy the dower debt. The question arose whether these payments satisfied the husband's obligation The judicial committee held that such payments were not to be treated as having been paid in satisfaction of uh, dower debt. The right to of friends, I have already discussed that prompt dower can be enforced by refusing the prohibition, and this was confirmed by the court in Anis Begum versus Muhammad Istafa Wali Khan. Justice Shah Suleiman uh, held that a suit, if the husband filed a suit for the restitution of conjugal rights before the prohibition, non-payment of the prompt dower is complete defense. The non-payment of the deferred dower by its very nature cannot confer any such right of refusal on the wife. The right to enforce the payment arises only on the death or divorce or the happening of a specified event. Since the dower ranks as a debt and widow is entitled, along with other creditors of her deceased husband, to have it satisfied out of his estate. Her right, however, is the right of an unsecured creditors. She is not entitled to a charge on the husband's property unless there be an agreement. In case of deferred dower, if there is a death of the husband, then wife will be entitled to realize the uh, deferred portion of the dower from the uh, from the legal years of the uh, deceased in the ratio in which they succeed to the property of the deceased husband, or she can file a suit for the recovery of her unpaid deferred dower from the property or income arising from the property of the deceased. Therefore, the deferred hour normally, the right to realize the deferred hour normally arise only in the two events under two situations. One on the dissolution of marriage by divorce, another on the dissolution of marriage on the death of the husband. However, on the death of the husband, if the wife has come into the possession of certain portion of the property of the husband lawfully and peaceably, she will be entitled to retain the possession over such property until her entire amount of deferred dower is fully satisfied. That where the widow is already in the possession of certain portion of the property of her husband, in lieu of the payment of her deferred dower or payment of in lieu of unpaid amount of the dower, then on the death of the husband, the widow will be entitled to continue retain the possession over such property until her entire amount of the unpaid dower is fully satisfied out of the rent and income of the property in possession. This right of the widow is known as widow's right of retention. Widow's right of the retention refers to the right which the widow exercises over the property of husband, which was in her possession peaceably and lawfully in lieu of the payment of the amount of the dower. And in the meantime, there is a death of the husband, then widow will be entitled to retain the possession over such property and she will be entitled to retain the possession over such property until the entire amount of the dower of the widow is settled. For example, suppose H is a Muslim. He is married with W, a woman. At the time of the marriage, the dower is fixed, and a fixed amount of the dower is rupees 1 lakh, say for example, rupees 1 lakh. At the time of fixing the dower, it was also agreed upon between the parties, that is H and W, that 50% of the fixed or specified dower will be prompt, and 50% of the fixed dower will be deferred. Prompt, here again, I repeat that prompt means that 50,000 of the 1 lakh rupees was payable to the wife on her demand by the husband. 50%, that is 50,000, was rendered deferred, means it was made payable uh, on the death of the husband or dissolution of the marriage. Suppose there is a death of the husband H. He paid the prompt dower to his wife W, but deferred dower was pending for payment. He has died, and then after the death of the H, 50,000 will be just like unsecured debt over the property of the H, and therefore widow along with other creditors will be entitled to realize her unpaid amount of the dower from the property of the deceased. But at the same time, if a widow has come into the possession of the certain portion of the property of the husband H, or she was already in possession of certain, because this was, say for example, the entire 1 lakh was prompt dower, and for the payment of the prompt dower, the husband has given the possession over his certain property to his wife W for the realization of the entire amount of the dower, including payment prompt and deferred. Say for example, 20,000 was realized from the income of the property, but in the meantime there is a death of the husband H. She is already in the possession of the property for the realization of the amount of the dower. 20,000 was realized, but 80,000 was left. In the meantime, there is a death of the husband. Husband dies. Then, and widow was already in possession of certain part of the property of the dead. Widow will be entitled to retain the possession over the property until the entire amount of the 80,000 is realized from the income or rents of the property. This right is known as right of retention, and this right has been recognized as valid right by the Privy Council in Mehr versus Chaudhary Wakil Ahmed, and some other cases. This right has been affirmed as a lawful right of the wife, which can be exercised in the event of death and pending pendency of the unpaid amount of the dowry. Umaira Bibi versus Zubaida Bibi is another case on the subject of the widow's right of the retention, and it was held that dower is an essential incident. Zubaida Bibi versus Umaira Bibi. Umaira Bibi versus Umaira Bibi versus Zubaida Bibi. Umaira versus Zubaida Bibi. So in this case, it was held that dower, since the dower ranks as a debt and is an essential incident arising from the contract of the marriage, to which the wife is entitled, and in the event of the death, the widow will be entitled to realize it from the property of the estate of the husband. So this right is a very crucial right of the wife in the lifetime of the husband. And after the death of the husband, the widow will be entitled to this right to realize her unpaid amount of the dower by retaining the possession over the property, provided the possession was obtained by the widow peaceably and lawfully. Ladies and gentlemen, there has been a question whether this widow's right of retention is heritable and transferable. The courts in successive judgments have held that the right is heritable but not transferable because a widow is allowed to retain the possession over part of the property of the husband only in lieu of her unpaid amount of the dower. And therefore, she is allowed to retain the property of the husband only to the extent of amount of the dower, that until the amount of the dower is satisfied, she is entitled to hold the possession over the property. But as soon as the amount of the dower is fully satisfied, she will be required by law to release or relinquish the property to the legal heirs of the deceased. Or suppose during the continuance of the possession over the property, the legal heirs have paid the pending amount of the dower. So as soon as there is a clearance of the unpaid amount of the dower by the legal heirs, on the payment of the entire amount of the dower, the widow will be liable to relinquish or to release from her possession the portion of the property which is under her control. For example, I am giving the example of this that say for example, H is a Muslim, he dies leaving behind his widow, his son S, and his son S1, S2. Now, when he dies, then he dies leaving behind his wife as a widow, S son, and SS. The amount of unpaid dower of the widow was rupees, say for example, uh, 20,000. 20,000. It is a 20,000. So widow is entitled to realize this 20,000 from the property of the deceased after his death. But say for example, this is charge which is running over the property S1 and S2, they decide to pay it to the widow. And pursuant to the realization of this amount, say for example, she is in the possession of certain part of the property of the deceased S. So here HW will be entitled to retain the possession over the property for the realization of his unpaid amount of the dower. But S1 and S2, they are ready to pay rupees 20,000, 10,000 being paid by S, and 10,000 is being paid by S2 to the V2. As soon as this payment is made by S1 and S2 to the W1, W will be required by law to, and his right of retention will terminate, will come to an end on the payment of this amount of the dower by. So here, this right is not transferable. There is a agreement or there is a consensus of the judicial opinion on this point that right of retaining the property in lieu of unpaid amount of the dower under Muslim law is not transferable, meaning thereby that widow cannot transfer or dispose of or the property in her possession in lieu of the maintenance by sale or by gift. Because what is his right? That his right is simply to hold the property and will continue to hold the property until the entire amount of the dower is satisfied out of the income or rent of the property. So this is therefore this right is only heritable right but not transferable. The Supreme Court of India in conclusion versus Kadunisa held that the widow has no priority over other creditors, but that Mehr as a debt has priority over the other years or over the other year claimants. And heirs of the deceased are not personally liable to pay the dower; they are liable to the extent of the share of the inheritance which comes into their hand. Now I am going to discuss the effect of apostasy on the dower. Apostasy is called as Rida in Muslim law, and apostate is called Murtad, which means one who turns back from Islam. A person who Muslim prevent who later rejects. Murtad means the person who uh, discard the religion of the Islam and embraces some other religion, maybe Hinduism, maybe Sikhism, maybe Christianity, anything. So apostasy has a huge. Say for example, here A is a Muslim and is married with W, and the amount of the dower fixed in their marriage was rupees 50,000. Say for example, 50,000. Now, after the marriage, he has become Murtad. Means he has converted to the Hinduism, he has become Hindu. So now the point is that as soon as A has become Hindu, converted to the religion of the Hindu, what will happen to this amount of unpaid dower? And therefore, what will be the impact of this on the Muslim personal law, impact on under Muslim personal law? It is believed that apostasy of a man from Islam denotes immediate dissolution. On the other hand, apostasy by the wife from Islam does not denote immediate dissolution of the apostasy is dealt under Section 4 of the Dissolution of Marriage Act 1939. So, what is the effect of conversion or apostasy to another faith? The renunciation of the Islam by married Muslim women and her conversion to faith other than Islam shall not be by itself operate as dissolution of her marriage, provided that after such renunciation or conversion, the women shall be entitled to obtain a decree for the dissolution of her marriage on any of the ground mentioned in section 2. Provided further that provision of this section shall not apply to the women convert to the Islam from some faith and who embraces her from faith. As per section 5 of the Resolution of Muslim Marriage Act 1939, a married Muslim woman shall have the same right in respect of the dower under dissolution of marriage. Uh, the dissolution of marriage under the act, even though made after apostasy of the wife, does not take away her right to dower. Relinquishment of the dower and its conditions. The wife has power to relinquish or give away her whole dower or any portion of it in favor of her husband or his. Yes, only if following condition are fulfilled. Time. Remission can be made at any time after the marriage, whether or not it has been consummated. No remission of the dower can be made before or at the time of the marriage. It has been held by the court in Najmun Nisa versus Siraj. Further capacity of remission, only a major wife with sound mind can make a remission. Regarding the age of majority, there are differences among the courts. On the one hand, Patna High Court are of the view that age of majority for the purpose of making the remission should be 18 years. As under the Indian Majority Act, it should be 21 years, but Allahabad High Court hold the opinion that age of majority is to be determined under personal law, that is on attaining the puberty. And Qasim Hussain versus Bibi Qasim Kanis, year 1923, it was held. Remission can be considered, can be made even without consideration or however, the remission should be made by the wife with her free consent. Here, free consent means the consent as defined under Section 14 of the Indian Contract. A consent is free when there is no coercion or undue influence, etc., etc. When the wife is under the mental tension, such as when her husband is on his deathbed or has died, at that time, if she makes a remission, her consent cannot be said to be free. Acceptance of dower, remission of dower. Acceptance of remission of the dower by husband or his guest is not compulsory. But if the husband refuses to accept the remission, then it returns to the wife. So here, what is necessary that acceptance is necessary. But if husband refuses to accept remission, then it returns to the wife. Condition: the remission of the dower may be conditional. In lieu of the dower, the wife may agree to receive an annuity at the time of the marriage. If an agreement is made that wife is not competent to relinquish her dower or without the consent of her relation, the agreement will be violated and remission without such consent would be violated. It is for the defendant who set up a case of relinquishment to show how it was made by the woman voluntarily and by her own free will and without any pressure. Now the next point I am discussing, that is doctrine of wali retirement or khilwat sahi. When the husband and wife are alone or together under the circumstances that present no legal, moral, or physical impediment to the marital intercourse, they are said to be inviolate retirement. The term is also famously referred to as khilwat sahi in Muslim law. Ladies and gentlemen, it may be exemplified. Let's suppose there is a marriage between two persons, two Muslim A and B. They are living in isolation in a separate room as a husband and wife. Presumption will be that they have had the copulation or sexual intercourse with each other or marital intercourse with each other. Though in fact there may not be copulation or physical relation between A and B, but presumption of the law will be that they were in relation and they have consummated the marriage. So when there is a fair and enough opportunity of consummation of the marriage due to the attending facts and circumstances, then this is known as khilawat sahi under Muslim. A valid retirement in Muslim law has the same legal effect as actual consummation as regards the dower. The establishment of the paternity, the observance of iddat, a wife's maintenance during iddat, that bar the marriage with the wife's sister, and bar of the marriage imposed by the rules. Meaning thereby that when the parties to a marriage have had a fair opportunity of consummation of the marriage, law will presume that marriage has been consummated and this will give rise to the full payment of the amount of the dower. Moreover, if the child is born from such wedlock, the child will be presumed to be the lawful offspring of the A and B. Third is that in case there was a opportunity of valid retirement and there is a resolution of the marriage thereafter, then B will be required to observe the period of the iddat and A will be required to pay the amount of the dower to the B, the wife. The fair opportunity of consummation of the marriage gives rise to the opinion that marriage has been consummated, and this type of the consummation is called as khilwat sahi. So, and it has effect on it has effect, but it has not had the same effect as actual consummation as regard the bar of his wife's daughter or bar of the remarriage between the divorce. In both the cases, there must have been actual consummation. So the above except except admits to the presumption of consummation if there is a violator. If the husband and wife cohabit or live together without there being any other circumstance inhibiting or preventing their physical union, it can be presumed unless otherwise proved that marriage has been consummated. Incidence of dower after married retirement. Dower in following cases shall become payable on the cohabitation. After married retirement, on the death of either party to the marriage. The whole dower does not become payable merely on the marriage contract. Indeed, the whole dower becomes payable after the valid retirement. And fees marquises agree on this point. In support of their view, there are almost, amongst others the following traditions on which the Sunni jurists have reached a consensus. Holy Prophet is reported to have said that person, the person who removes the veil of a woman and looks at her, the whole of the dower becomes due to him on you, whether act of population took place or not. It is narrated from Saad bin al-Musayyab, one of the companions of the Holy Prophet, that Umar has ordered that a man, when he, after marrying women, uncovers her veil, the whole of the dower shall assuredly become due on her. In case of irregular marriage, in case of the irregular marriage, there is a consensus of the opinion among the jurists that payment of entire dower becomes incumbent on the actual purchase. According to the Hanfis, Maliki, however, while retirement is equivalent to cohabitation, In certain ways, if there has been valid retirement, according to them, the entire dower becomes incomplete. The dower, it does not matter whether cohabitation has taken place or not. However, valid retirement, according to the Sunnis, shall not be the substitute of sexual intercourse. An irregular marriage does not necessarily lead to the sexual intercourse. In case of irregular marriage, therefore, no dower for women shall become due without sexual intercourse. Hence, if women divorce prior to the sexual intercourse in an irregular marriage, no dower shall be become due to her. In case of divorce after valid retirement, the entire dower becomes due at once. According to the Hanfis and Malikis, the dower on account of the valid retirement becomes promptly and mandatory. If the divorce is pronounced or marriage contract dissolved or after valid retirement, the entire dower shall at once become due after it be prompt or different. The basis of the principle is that marriage contract becomes because of that the marriage contract because of the divorce or dissolution comes to an end, hence it becomes obligatory that dower be paid at once.